Hello, everyone, and welcome back to another episode of Confidential Bulletin. I'm Jock Condy, President and CEO of the California Restaurant Association. On today's podcast, we will focus on understanding California's wildfire smoke regulations, an increasingly important topic for our industry. The restaurant and hospitality sector has been hit hard in these fires, not only right now in Los Angeles, but in other regions over the past few years. Restaurant owners not only lost businesses, but they are accommodating employees who may have lost everything too. They are helping provide food to families who have no kitchen anymore, and they're trying to weather these fires themselves. And with all of that, they're also trying to comply with the thicket of laws and regulations that govern employer obligations during these stressful and tragic events. And even for business owners not directly impacted by the fire's destruction, if they're in or around a smoke-laden fire zone, compliance with these employee accommodations may be required as well. And given that these laws are enforceable under the state's Private Attorney General Act, extra diligence is necessary. So today we are joined by two very smart lawyers who will share their insights to help you navigate the do's and don'ts related to the wildfire smoke regulations. Christine Long is a partner at Berliner Cohen LLP, and Vance Piggott is senior counsel at Kronick, Moskovitz, Tiedmann Girard. So welcome to you both. I appreciate you joining us, and we're looking forward to an informative session. Let's start with you, Vance. Tell us, what are the basic rules businesses need to know regarding accommodating employees?
Yeah, thanks so much, John. So let's talk about first the wildfire regulations. So these are a newer set of regulations from Cal OSHA. And really, as wildfires have picked up over the last few years and become more severe, we've seen those regulations be revised and amended and kind of be refined a little bit. So the most important and easiest thing that that employers should do anytime they're even potentially affected by wildfires is really pay attention to the state's Department of Industrial Relations website. That's where you're going to get the most up-to-date information directly from the state DIR. They do a pretty good job of putting out information that's going to be useful for employers. So check there anytime you might be dealing with some type of state of emergency, and they'll have the latest regulations.
Vance, I was wondering, you could tell us what kind of responsibilities an employer should be looking at or being aware of when a wildfire breaks out in their area.
Yeah, of course. The general rule is employers must provide a safe and healthy work environment for their employees. So anytime that there's wildfires or severely bad air quality in the area, employers have obligations under Cal OSHA regulations to provide some protections depending on specifically what's going on. So there are specific regulations which apply to wildfires. These apply when air quality index reaches 150 or above, or where the employer reasonably anticipates employee may be exposed to wildfire smoke. So in those situations, employers must regularly monitor local conditions. So that's both fire reports and evacuation zones and air quality index. Employers who have outdoor work areas, or if the employees work inside in areas without mechanical ventilation systems, employers have an obligation to evaluate the current AQI, that air quality index. And specifically, there are a few different air quality indices, but you're going to want to look at that PM 2.5. That's that fine particulate matter. So you need to do that at the start of each shift and then periodically throughout the day if that air quality is getting up there or if there's direct exposure to smoke. Second, employers need to provide training to employees on the requirements of the regulations and develop some what we call administrative control measures to reduce employee exposure or the severity of that exposure. So when we talk administrative control measures, those are things like keeping the doors closed, keeping employees inside, turning on those ventilation systems, perhaps reducing the work schedule a bit, providing additional breaks, things that might alleviate some of those effects of that harmful smoke on the employee. And then lastly, in these situations where there is an increased risk of dangerous situations, be really diligent about documenting what safety measures you're doing and the decisions that you're making in order to be sure that you can reduce that liability.
So you mentioned, Vance, about an employer's duty to check for that air quality at the beginning of each shift. When does that really kick in? Because some of these fires are so far away from these businesses. So, like, how do they know when to start checking?
Yeah, so it's a little bit circular in that the regulations don't apply until AQI is 150 or above. So that obligation to monitor doesn't apply until the AQI is high. But how do you know the AQI is high? Here, I think just common sense. If you can see that hazy smoke kind of in the area, if you know that you have wildfires somewhat nearby, be monitoring that AQI and just stay on top of it. There is good resources out there. The EPA has the airnow.gov. They actually just have an app, and just before we started today, I was looking through the app. You can really fine tune it to your specific area. You can get notifications for when your air quality is getting up there. So use some common sense when you think that air quality might be getting bad, or you're near wildfires. Really be monitoring and use these tools that are out there. And once those levels do reach 150, then that's the point where you're going to want to go into all of the rest of those requirements to ensure your employees safe.
When you say the rest of the requirements, what does an employer have to do if that air quality gets really high, the unsafe conditions above 151?
Right. So once you get above 151, there's an obligation to make available respirators for your employees. So that's number one. You're also supposed to encourage the use of those respirators. You don't have to require them, but you should at least encourage them. Now, if AQI gets above 500 into the severely unhealthy zone, then at that point you are required to mandate respirator use by your employees.
Are they required to close their facility if it gets over 500?
No, not necessarily. They can remain open as long as you have the respirators and you are mandating the use of those respirators for your employees.
Now, during COVID, we saw a lot of things regarding masks, and some of those masks that are required for the COVID might differ from fire. What are the masks or respirators that are required for employees in this type of situation?
So a couple different options. They need to be approved by NIOSH, the National Institute of Occupational Safety and Health. Most common ones are going to be the same a lot of employers use for COVID, meaning those N95s. They're more than just those kind of soft blue masks, the N95s or the white ones. They filter out specifically that particulate matter. N99, N100, R95, P95, P99, and P100 are also options. I think probably we see most people using those N95 being the cheapest and easiest to obtain.
And then if a business under this requirement to provide masks or provide alternatives because of the air quality, are there any requirements on how that gets communicated to employees? Are there any posting requirements, notices, that kind of thing?
There's not specific requirements in how it's disseminated, except that it must be communicated to employees and it must be done in a way that they will understand. So if you have employees that speak multiple languages, you need to be sure you're communicating with them in the language that they are most comfortable with and a language that they understand. But honestly, the more you communicate and the more methods that you use for communication, probably the better. Email, text message, phone call, however you typically use those, probably good use here.
Got it. And then in terms of that communication, do you have to reimburse the employees now because they might be using some of their own devices for these communications?
Yeah, so probably the question I've been getting most from employers recently is reimbursement questions. And I'm sure you have too, Christine. So absolutely, anytime you are having an employee use a personal device or anything that employee owns themselves, whether it be a vehicle, a cell phone, they need to be reimbursed. Cell phone reimbursement should be proportional to the amount of its use. So if it's just some basic communications back and forth with the employee about these situations, an employer might want to consider some amount of a reimbursement, likely in a fairly small amount, maybe $10, maybe $20 for a pay period if they're required to use their cell phone during that time.
Okay, got it.
Okay, Christine, I think I've covered the regulations. I want to have you walk through a couple scenarios of how wildfires might be affecting both employers and employees and run through some situations here. We've seen in some of these really hard-hit areas, businesses that want to stay open despite evacuation orders. If a business wants to stay open, can the employer require employees to come to work in an area under a mandatory evacuation?
No. But the important thing for the business that wants to stay open to do is to look and see what exactly that order says. So if it's an absolute mandatory evacuation, everyone get out, they can't mandate that. But if it's some type of other order, like putting them on a watch or putting in curfews or things of that nature, then they could maybe require the employee to come in and continue to work. They're just going to have to be mindful of the orders, and then also remember that those orders are constantly changing, and then staying abreast of them so they don't get in trouble.
So let's assume employees are not able to work due to emergency orders closing a business. Are employees entitled to use paid leave, sick leave, anything like that to cover time off caused by the wildfires?
There's no entitlement, but the employer could allow them to. So basically, paid leave, sick leave is for when an employee is actually ill or they're caring for themselves or an ill family member. Starting this year, January 1, 2025, SB 1105 went into effect, and that specifically covers agricultural workers that might be subjected to having to work in conditions where there's excessive heat or fires that are in place. And in those instances, the state says starting in January 2025, the employer has to allow the employee to use sick days when they have those orders in place because of those conditions. That only applies to ag workers, but it provides a good framework for an employer, in this instance in the hospitality industry, to say, yes, we're going to allow you to supplement your pay with either some PTO or sick leave that you have available since we have to shut down. And I think in those instances, the employer would not get in trouble if they allowed that.
One thing I know we've heard questions on is whether an employer can require an employee to report to work if the employee lives in an area impacted by the wildfires, like the Altura fire, but the workplace itself is not impacted by those fires.
This is really going to be very fact specific and deal with the specific employees. It's hard because this business that's in an area that's not impacted wants to stay open, wants to serve its customers. And if it has a remote workforce that's driving in and they say, hey, we can't come in because we're displaced, there is no statutory protection that says, hey, they don't have to go to work. But at the same time, if that employer runs a problem of maybe losing a good employee, having the employee file a claim nonetheless, claiming that they were discriminated against or treated differently, and then saying that they should have been provided an accommodation because it was a state of emergency in the area that was affected. So in those instances, especially if it's the day that the fire impacted them, I think they should provide accommodations. If it's weeks later and the employee says, hey, I live in an area that was affected, I can't come to work this week, the employer might need to reevaluate that and say, okay, is this employee really taking advantage? And is there some other reason they're not coming to work? So it's really going to be a case-by-case basis.
So in those situations where an employee has lost their home, are they entitled to family medical leave or CFRA leave?
That's a great question. And I think a lot of times employees get confused with the types of leave that are available. So in California, we have leave that the employer must provide that is time off. And then there are other things in which the employee can receive compensation. In regards to the time off under the Family Medical Leave Act, which is federal, or the California Family Rights Act, which is state of California, the employee is only allowed time off to care for themselves, a family member, or a designated individual to take care of a serious health condition. So the loss of their home is devastating for certain, but it might not trigger a right for FMLA or sick relief. But if this person is suffering severe depression or someone in their family was injured by the loss of that home and is in the hospital, then you might give them time off. And the most important thing for employers to remember is that the employees have a period of time to get the necessary paperwork. So if an employee says, look, I want one of my statutory leaves, The employer has to give them time to bring in the necessary paperwork. Generally, that's somewhere between 15 and 21 days, depending what statute we're talking about. If the employee can't bring it in after that, then that leave becomes retroactively unprotected leave, and then the employer may be able to terminate the employee. But in those situations, if an employee is asking for that protection, that's a good opportunity to call the helpline and say, hey, what do I do in this specific fact pattern? Because it's really going to be factual as to why the employee is asking for the time off.
Okay, so there might not be an entitlement to that protected leave due to the loss of home itself, but perhaps some of the fallout from that might then entitle them to one of those forms of protected leave. Is that right?
Yes, excellent summary of what I said. Thank you.
Christine, let's go back to the situation where the employer itself is affected by the wildfires or smoke. In situations where the business closes early due to smoke or evacuation orders, is that employer obligated to compensate employees? For example, if an employee was scheduled for a 6-hour shift, but because of a fire, that business closes down, is that employee entitled to any additional pay on top of the hours that they've worked?
The general answer is no, but employers are going to be asked by the employee to be compensated. And the reason is because most employees are pretty well educated on the reporting time pay laws. And what those laws provide is that if an employee has a scheduled shift that's 6 hours and they're only given a fraction of that shift and it's less than half, then they're entitled to compensation for the part they didn't get. So in a 6-hour shift, if the employee worked 2 hours, they're entitled to another hour's pay because they have to be paid at least 50% of their shift. And that would apply any time that they're scheduled to work or in any jurisdiction in which there's a scheduling requirement where the employees receive their schedule in advance. So employees have been coming forward, and we have been hearing that from employers asking, like, do I owe them that money because I had to close due to an order? And the question really is going to become, why did the business close? If the employer decided, hey, I want to close because I don't think it's safe, but there's not an actual order, in that instance, it's going to be gray. If there's an actual order in place, absolutely they're not owed anything. That's considered an act of God or state of emergency. They're not owed any additional compensation because it's not the employer's decision. If the employer is in an area that's not affected, but personally has an area that is affected and they say, I'm shutting down, then in that instance, the employer would owe money. So it's going to be fact specific. And if there's an order in place, the employer would be protected and would not owe that additional compensation.
Okay, so what about a situation where business operations are interrupted because of a power outage? Are employers required to compensate employees for periods of time where there's a power outage?
A power outage, they could have to be paid. So it depends on what's going on with that power outage. So if there's a live line out, sometimes there'll be an order for people to evacuate, get out of the area, or if there's another power failure, such as a gas leak, that's another form of state of emergency. But if the power simply goes out and affects the business, the labor commissioners traditionally held that the employee is entitled to at least 50% of their pay for that shift. So the employer should go ahead and pay in those instances.
So, Christine, it sounds like to me, kind of the general rule is if it's just an employer decision to close, there is an obligation to pay reporting time pay. But if there is some requirement or order which obligates that business to close, then they're excused from paying that reporting time?
That's correct.
Okay, so how about this one? Employees are having to drive longer times due to displacement, or part of their commute to work is blocked because of a fire, something along those lines. Are employees entitled to additional time that it takes them to commute to and from work?
No, they're not entitled to additional time. It's unfortunate, but an employer never owes in any situation commute time. But what we have seen is some employers, because they're not getting deliveries that they used to have, are asking employees to maybe stop at the grocery store on the way in and pick up supplies for the restaurant, or swing by and pick up some, paper products or things of that nature. And the employee is having to make those stops on the way. Then from the time they make that stop to the time they get to the restaurant, that is all compensable time because now they're under the employer's control. So because this is kind of this situation that's very tense for everyone, and they're trying to figure out how to just keep their business afloat, they might be taking employees up on their good nature, saying, "Hey, yes, I can stop and pick that up for you, boss, on the way in. Hey, yeah, let me grab that." But when they do that, now that employee needs to be paid for that time that they're spending picking up those supplies. They need to be reimbursed for their mileage and, of course, reimbursed for what they buy. But that time spent and the mileage driven, all of that would be compensable as well.
And what about a situation where an employer owns multiple restaurants? One restaurant that the employee typically works at is closed, and they have that employee travel to another restaurant that's maybe a further distance. Is there some requirement that the employer provide additional compensation for the employee there?
Generally, the rule is no. The rule is that when you report to work, the time from when you leave your home to you report to work is not compensable. If that drive becomes excessive, let's say that an employer has another business in San Diego and these fires are affecting LA County, there might be something then that would be compensable in those instances. But generally, if their commute was 20 minutes and now they're going to have to go 30, 35 minutes to another site, that's not going to be a situation where they have to be paid for that additional time.
Yeah, this stuff is so, if you think about the stress that a restaurant owner or a business owner is going through in a time like a wildfire, and all the laws that they have to be familiar with, it's overwhelming. Just listening to you both talk about these very specific, requirements, and then of course the yes if components is just hard. Vance, Christine, I appreciate you joining us, and I really appreciate you being such important partners in our CRA Legal Center. And importantly, for you, our members, remember that every month you get a 15-minute call with our legal partners like Christine and Vance. And certainly as we're sort of going through this difficult period in Southern California, no question, given we're California, and, wildfires are a season just like summer and winter, unfortunately. Our legal center is available to you to answer questions. Sometimes it may not be clear, but you can rest assured that Vance and Christine can offer that clarity for you. So thank you again. If you have any questions relating to anything concerning your restaurant operations, remember to reach out to helpline@calrest.org. They can help you not only with topics we covered here today, but anything from incorporation, zoning, or wage and hour questions. So everyone, let's continue to stay informed and support each other in navigating these challenges. And again, Christine and Vance, thank you for joining us today. Stay safe, everybody.
Thank you, John.
Thank you.